Chapter 8. Common Law Review. I have presented two independent arguments, one source-based and one conceptual, that support an ability and an obligation of common law judges to develop the law by refusing to enforce unjust laws. I have called this common law review. In this chapter, I will explore in some detail how the theory of common law review might translate into practice. The discussion in this chapter is generic. It holds whichever way common law review is established, conceptually or by case law. In particular, I will do 5 things in this chapter. First, I will examine some analytic features of the doctrine. Second, I will describe what I take to be the proper form of the power of common law review and the appropriate judicial attitude toward its exercise. Third, I will consider common law review's interaction with stare decisis and legislative supremacy. Fourth, I will relate the exercise of common law review to broader themes of common law constitutionalism. Fifth, I will respond to a classic concern of legal theory regarding unjust laws, to avoid the misapprehension that my argument tracks the so-called Radbruch formula. Implicit, and at times explicit in this discussion, are my responses to 3 likely objections to common law review. 1. That the doctrine is an unwieldy and unworkable notion. 2. That there is no room in the law for judges to rely on their own idiosyncratic moral beliefs. And 3. That there is far too much danger of its overuse by undisciplined or irresponsible judges. As I will explain in this chapter, and in the one that follows, these concerns might seem acute in the abstract, but they ought not to be considered in the abstract. In the common law tradition, these concerns arise only in the context of specific cases. And in this case-specific context, these concerns are far less pervasive than they might seem. The judicial authority I describe is a feature of all common law systems, although its constitutional description will vary from jurisdiction to jurisdiction, and although individuals will rightly disagree about the proper instances of its invocation. Those disagreements, whether expressed in judicial opinions or elsewhere, are a necessary and healthy aspect of the common law's dialogic nature. But those disagreements about when and whether the courts should exercise their review authority in particular cases should not be taken for doubts about whether the courts have that authority at all. A. Analytic features. 1. The epistemic threshold. Stephen Perry introduced an idea called the epistemic threshold to help explain the proper balance between judicial deference to precedent and independent judgment. If the facts of the present case fell within the scope of a judge's reasoning in an earlier case, she would be bound to decide in the way indicated by her prior reasoning, unless her conviction that she had been wrong rose above a certain epistemic threshold. In that event, she would be free and indeed obligated to decide in accordance with her present assessment of what the objective balance of reasons requires. The point would be to introduce a certain stability into the general legal environment, without at the same time sacrificing completely the judge's ability to decide cases according to her own best present judgment. In the preceding excerpt, Perry discusses the epistemic threshold as it relates to the reassessment of a judge's own prior decision. He explains in a later article that the concept applies with equal force when a judge reviews the reasoning of a different court. If judges are sufficiently confident that an earlier court was mistaken, then they can, to an extent that will vary with the circumstances, rely on their present moral beliefs to decide the case at bar and, in the process, change the law. Building on Perry's formulation, the epistemic threshold concept captures 3 key facets of common law review. First, a judge cannot invoke the power of common law review unless she is sufficiently certain that a mistake was made, or, to repeat Perry's phrasing, unless her conviction rises above a certain epistemic threshold. Second, the epistemic threshold links the judge's moral reasoning to her legal ruling. The mistake with which the epistemic threshold and common law review is concerned is a moral mistake, and not just a legal error, a moral mistake that has led to or underlies a legal ruling. Third, once the epistemic threshold is crossed, the judge is obligated to reach a legal decision in accordance with her best judgment, informed by her moral beliefs. It is not entirely clear whether Perry believes the obligation triggered by the epistemic threshold is absolute or supererogatory. In the first passage I quoted, he states that a judge is free and indeed obligated to decide in accordance with her present assessment of what the objective balance of reasons requires. This suggests that once the epistemic threshold is crossed, the judge must act to correct the perceived error. In the second extract, however, Perry writes that when judges are sufficiently confident of an earlier court's mistake, they can rely on their moral beliefs to change the law. I set out to justify a legal basis for judges to refuse to enforce unjust laws. It would be perfectly consistent with my stated project for me to claim that once the epistemic threshold is satisfied, a judge may refuse to enforce unjust laws, but not that she must. Surely, it would be satisfying for me if I convinced readers that common law review grounds a supererogatory judicial authority to refuse to enforce unjust laws. Nevertheless, I will try to do even more. For reasons I discussed in the previous chapters, I believe the obligation is absolute. Once the epistemic threshold is crossed, a judge not only can, but must refuse to enforce an unjust law. Where common law review is concerned, it seems to me that the epistemic threshold rotates on two axes: certainty and gravity. The axis of certainty, on which Perry's analysis centers, emphasizes the necessity that a judge be sufficiently confident of a prior error before disavowing precedent. For common law review, this is only half of the story. Not only must a judge be sufficiently certain that a mistake was made before refusing to enforce a particular law, but the judge must also be convinced that the issue at stake is grave enough to justify the extraordinary power of common law review. This is the gravity axis of the epistemic threshold. Certainty relates to the confidence that an error was made. Gravity relates to the importance of that error. Of course, the idea of certainty pertains to the gravity axis, as well insofar as a judge must be certain, not only that a mistake was made, but also that the mistake involves a matter of sufficient weight to justify the exercise of common law review. I separate certainty and gravity, though, to underscore the fact that a judge can refuse to enforce an unjust law under the aegis of common law review, only where the injustice is profound and compelling. Common law review cannot be invoked by judges who wish to correct a trivial detail or even a moderately important mistake made by a legislature or a higher court. Common law review is concerned with iniquity, not inequity. The very idea of an unjust law recalls the gravity component of the epistemic threshold and should preclude judicial misinterpretations of the aspect of gravity in the practice of common law review. Common law review requires the judge to be convinced that a mistake has been made, and that it is a serious mistake, or more carefully, that it is a mistake about something serious. To this point, I have considered the epistemic threshold only in relation to judicial appraisal of existing case law. It applies in the same fashion when judges review and assess the injustice of legislative enactments. My primary interest in the epistemic threshold as it relates to common law review is straightforward. Before a judge can properly engage in common law review, she must, after critical and searching reflection, be thoroughly convinced that a particular judicial decision, legislative enactment, or executive action was mistaken, and that it involves an issue of the first moral magnitude. When and only when the judge is satisfied that both axes of the epistemic threshold have been reached, the judge can and must develop the law by refusing to enforce or endorse the unjust decision, legislation, or action. The previous paragraphs touch on an important jurisprudential debate that I should pause to address. Exclusive legal positivists, such as Joseph Rass, believe that the law sometimes requires judges to engage their best evaluative moral reasoning when reaching legal determinations, even when changing or developing the law. For these legal theorists, however, the judge's moral evaluations, while necessary to the law's articulation, always remain external to the law itself. In contrast, Ronald Dworkin maintains that the adjudicative process of constructive interpretation always requires judges to engage in moral reasoning when reaching legal determinations, and that the judge's moral evaluations are part of, and cannot meaningfully be separated from the law itself. An example may help clarify the relevance of this dispute for common law review. Imagine a case where a plaintiff railroad company has sued a defendant passenger of African descent for refusing to remove himself from a whites-only railroad car in violation of a statute passed in the wake of Plessy. Common law review holds that in a case involving a sufficiently unjust law, such as this one, a judge has a legal obligation to develop the law in accordance with her moral convictions by refusing to enforce the unjust statute against the defendant. I have argued that the legal basis for this judicial obligation can be traced either to common law legal sources or to common law legal concepts. A Raysian may prefer sources, and a Dworkinian may prefer concepts, but notice what they agree and disagree about. They agree that judges have a legal obligation in this case to invoke their moral convictions when reaching a legal ruling. So they agree about the fundamental analytic structure and substance of common law review. They disagree, however, about the proper scope and limits of the judge's legal obligation. The Raysian would say that the common law instructs judges to use their moral faculties when reaching a legal decision, but that the decision is ultimately left to the judge's discretion. The Dworkinian would say that the judge's legal obligation runs all the way down to the specific decision reached, that is, that the judge has a legal obligation to engage in moral evaluation and a legal moral obligation to decide in the defendant's favor, given the parameters of the argument for common law review as I have constructed it. Even this disagreement is far less stark than it may appear. On Raz's view, the law may require a judge to consult morality, yet the law cannot dictate a particular result in a specific case where a judge has discretion. But for the common law judge who is deeply troubled by the racialist law's injustice, common law review establishes a legal obligation for the judge to decide in accordance with her felt moral convictions, provided that the epistemic threshold has been met. So in this case, for this judge, a Raysian who accepts common law review might well accept that the judge must reach a legal decision that coincides with her moral convictions. This is, on Raz's view, one of those situations where the judge's discretion is cabined by law. What is unusual, or perhaps, as I will explain in the next section, not so unusual, is that the judge is legally required to decide the case in accordance with her own moral beliefs. In an early essay, Raz himself explicitly referred to legal norms that instruct or require judges to invoke their moral convictions when deciding cases, and he noted the convergence between legal positivism and Dworkin on this point. Both positivism and Dworkin contend that courts are legally required to apply source-based standards, and both claim that they are legally required to follow certain moral standards, even when these are not source-based. Both further agree that the source-based standards determine which non-source-based standards should be applied by the courts and when. A Dworkinian would still wish to go much further, arguing that in every case, for every judge, if both dimensions of constructive interpretation are satisfied, the correct judicial decision is the one that eliminates injustice from the law or recognizes that the law, properly understood, did not permit the injustice in the first place. All I want to point out here is that for the specific instances where I claim that common law review is appropriate, a judge's legal obligation to decide in accordance with her moral convictions and evaluations is consistent with a variety of jurisprudential perspectives. 2. Personal convictions. The epistemic threshold, as I have construed it, and the practice of common law review itself are dependent on the personal convictions of the judge who reviews the law or action at issue. Common law review is dependent on the individual moral convictions of the common law judge. In the previous chapter, I explained that common law review is inconsistent with a belief that a judge's legal deliberations and determinations should be kept isolated and insulated from her moral beliefs. Now I want to consider the claim that a judge should and must consider morality when reaching legal decisions, but that the moral beliefs the judge should consider are the community's rather than her own. This is the view of Benjamin Cardoso, Melvin Eisenberg, Christopher Eisgruber, John Rawls, and others. Although Eisenberg's preoccupation is common law adjudication, he recognizes that the same principles apply broadly in constitutional and statutory adjudication as well. While this is an initially attractive position, it fails to account for certain difficulties raised in the previous chapter. The community as a whole may share a moral view that is abhorrent, and that has led to abhorrent legislation. Directing a judge to consider the community's moral beliefs will do nothing to correct injustice when those beliefs precipitated the injustice and perpetuate its existence. Common law review, then, involves the judge's own individual moral convictions. The epistemic threshold, as it operates in common law review, leaves to the judge alone the determination of whether and when the certainty and gravity prongs have been met. In these respects, common law review is quite close to a view expressed by Kent Greenewalt. Where authoritative legal sources leave an issue genuinely in doubt, I think a judge properly decides in accordance with firm convictions of moral rightness and social welfare that command wide support, even if these convictions are at variance with the theory that would best justify existing legal standards. Indeed, if the judge's convictions are very firm, and if the issue involved is of great moral or social significance, I think a judge may follow these convictions even if he does not think they are shared by most members of the community. A judge is an agent for change in the law in marginal cases, and just as a legislator, he sometimes may rely on his own strongly held views in preference to those of the community. Usually a judge will assume his own perspectives have broad support because his own intensive consideration of a problem may seem to him the best indicia of what others think or would think if they gave the problem equally serious thought. But I believe that a judge is sometimes justified in striking out on his own, even when he recognizes he has little support. That is appropriate, however, only if his convictions are very firm, and the issue involved is of great significance. Greenewalt and I walk a while together before we part ways. Our only real disagreement, albeit a significant one, is that Greenewalt believes judges should engage in this sort of critical reflection about the law only in marginal cases, by which he means only those cases where authoritative legal sources leave an issue genuinely in doubt. I conclude, pace Greenewalt, that judges must sometimes engage in this normative evaluation of the law in cases where the law is absolutely clear and absolutely unjust. To many, my claim might seem to be contrary to a government based on the rule of law. Some might argue, at the very least, that this places far too much undiluted power in the hands of unelected judges, allowing them to enforce their subjective moral beliefs under the guise of legality. Some might argue further that even well-meaning judges will inevitably misuse this awesome authority. But contrary to these objections, common law review can be a confined, practicable doctrine. A body of case law in the United States established a legal principle and a test that require of judges precisely the sort of analytic process based on an epistemic threshold derived directly from subjective moral convictions that I envision for common law review. Moreover, these cases demonstrate that this sort of legal test can be implemented by judges in a principled, responsible manner. In American law, the leading case that first established this legal concept and standard, known as the shocks the conscience test, is Rochin v. California. Some factual background is necessary to appreciate fully the Rochin holding. The Los Angeles County Sheriff's Department was informed that Antonio Rochin was selling narcotics. Acting on this information, 3 sheriff's deputies entered Rochin's home on 1 July 1949 and surprised him in his bedroom, where they found 2 capsules on Rochin's bedside table. One of the deputies asked Rochin, "Whose stuff is this?" In response, Rochin grabbed the capsules and put them into his mouth. The deputies immediately pounced on Rochin and struggled to wrench his mouth open and forcibly extract the capsules before he could swallow them. The deputies were unsuccessful, and Rochin managed to ingest, but not digest, the capsules. The deputies then handcuffed Rochin and brought him to the nearest hospital. Acting on the deputies' instructions, a doctor snaked a tube down Rochin's throat and forced into his stomach an emetic solution that induced vomiting. From the material Rochin regurgitated, the deputies recovered 2 capsules that proved to contain morphine. Rochin was convicted of possession of morphine in violation of a California statute. The 2 capsules were the primary physical evidence against him. His conviction was upheld by the state appellate court, Despite the appellate court's observation that the sheriff's deputies were guilty of unlawfully breaking into and entering defendant Rochen's room and were guilty of unlawfully assaulting and battering defendant while in the room, and of unlawfully assaulting, battering, torturing, and falsely imprisoning the defendant at the hospital. The California Supreme Court denied Rochen's request for a hearing over the objections of two state justices who likened the forced extraction of physical evidence from Rochen's body to a coerced confession. Writing for a unanimous court, Justice Felix Frankfurter, a judge not known for flights of judicial fancy, reversed Rochen's conviction, introducing the shocks the conscience standard into American law with the following passage. We are compelled to conclude that the proceedings by which this conviction was obtained do more than offend some fastidious squeamishness or private sentimentalism about combating crime too energetically. This is conduct that shocks the conscience. Illegally breaking into the privacy of the petitioner Rochen, the struggle to open his mouth and remove what was there, the forcible extraction of his stomach's contents. This course of proceeding by agents of government to obtain evidence is bound to offend even hardened sensibilities. Due process of law, as a historic and generative principle, says that convictions cannot be brought about by methods that offend a sense of justice. The shocks the conscience test is concerned with the moral reactions and convictions of individual federal judges. Governmental action offensive to judges' personal consciences and senses of justice violates the Rochen standard. In this respect, the shocks the conscience test differs subtly from the evolving standards of decency inquiry used to determine whether a particular form of criminal punishment should be considered cruel and unusual under the Eighth Amendment. The evolving standards of decency assessment requires judges to ascertain the prevailing moral beliefs of the community when determining whether a constitutional violation has occurred. In contrast to the evolving standards of decency inquiry, the shocks the conscience test appeals directly to the judge's personal moral convictions, not to the community's moral beliefs, when evaluating the constitutionality of certain categories of government action. The shocks the conscience test is a formulation of the substantive due process protections of the 14th Amendment. The test and that amendment are intended to prevent government from abusing its power or employing it as an instrument of oppression. As I demonstrated in chapters 5 and 6, this is the same purpose that grounds Bonham and Calder, and this is the specific goal of common law review. As established by Rochen, substantive due process prevents government from exercising public power in a manner that shocks the conscience. Substantive due process also prohibits government from interfering with rights implicit in the concept of ordered liberty. I concentrate here on Rochen, but it is worth remembering, in the context of the relationship of common law review to broader themes of constitutionalism, that both the shocks the conscience test and the values implicit in the concept of ordered liberty are attempts by the judiciary to articulate principled legal limitations on republican government and to protect the judicial process itself from abuse or misuse. From the beginning, the Supreme Court has articulated the meaning and scope of due process liberties under the 14th Amendment by explicit reference to Anglo-American common law principles and traditions, which concomitantly define fundamental freedoms and prevent undue governmental interference with those freedoms. The general substantive due process protection afforded by the 14th Amendment relates to and controls governmental actions by both the legislative and the executive branches. Currently, however, the shocks the conscience test is applicable only to abuses of power or egregious actions by agents of the executive branch of government. There is no theoretical or practical impediment, though, to the test's application in the legislative context as well. Even Justice Scalia, a critic of the test, acknowledges its apparent suitability to abuses of legislative power and suggests that the test has on one occasion been referenced by the Supreme Court when reviewing legislative action. In any event, the applicability of the test directly to the judicial evaluation of legislation is a tangential point. Of most interest to me, and of most importance to my argument, are the ways that the test helps me to counter criticisms of common law review. To those critics who would assert that common law review is impractical, improperly permits judges to rely on their subjective moral convictions or would lead inevitably to judicial misuse, I would respond that the shocks the conscience test addresses and defeates all of these concerns. The test has proven to be a flexible and viable doctrine in U.S. law for decades, without evidence of judicial abuse. Furthermore, the criticism that common law review permits judges to rely on their moral convictions when deciding cases fails to recognize that this is and has always been an intrinsic attribute of common law adjudication, even in what we now call constitutional cases. As I have argued at length, the common law has always expected its judges to engage their moral faculties whenever they are judging. The shocks the conscience test overtly integrates this feature of common law adjudication into an explicit legal standard. The test provides a close analogy for common law review. Like common law review, it is both notional and normative, conjoining a judge's moral convictions and evaluations with her legal obligations and determinations. It expressly incorporates a threshold moral determination into a legal standard against which governmental action is assessed. It requires that this threshold moral determination be made by individual judges in the light of their own moral faculties and sensibilities. And it is an especially stringent legal standard that will be met only in extreme situations. As with common law review, when the test has been satisfied, the offensive governmental action is voided of its legal effect. Also, as with common law review, review of government action under the test is uniquely a judicial responsibility, because ensuring that the government does not trample in an unconscionable manner on individual dignity is a bedrock duty of judicial officers. The shocks the conscience test helps me to show that common law review is not the radical or romantic notion it might first appear to be. Common law review can be viewed as an adaptation and application of a legal test for assessing executive abuses of power to the legislative context. Common law review simply transposes the analytic method of the shocks the conscience test to legislative as well as executive action. And where an abuse of governmental power has occurred, common law review affords judges the same authority found in Rochin. Common law review says that what binds police officers binds legislators too. The analytic method that I argue is appropriate for common law review might initially seem unconventional, but is well established and has been widely employed in U.S. courts since long before Rochin was decided. Common law review and the shocks the conscience test both leave room in the law for a judge's personal convictions. They both ensure that the law will not permit judges and judges will not permit the law to sanction government action deeply offensive to the judge's individual sense of justice. Practical considerations can be used to resolve many constitutional issues that do not turn on disagreement over moral or political ultimates. But what about the issues that cannot be resolved so? The judge has two choices. One is to say that if public opinion is divided on a moral issue, courts should leave its resolution to the political process. The other is to say, with Holmes, that while the political process is ordinarily the right way to go, every once in a while an issue on which public opinion is divided so excites the judge's moral emotions that he simply cannot stomach the political resolution that has been challenged. That is the position in which the first Justice Harlan found himself in Plessy v. Ferguson, and in which Holmes found himself from time to time. I prefer the second route. It leaves a place for conscience. A judge's refusal to enforce a law as written because it violates his deepest moral feelings is a significant datum. The preceding quotation leads me to a further response to the objection that common law review leaves judges free to impose their subjective moral beliefs onto and into the law. Judge Henry Friendly once noted that, while the Rochin test, conduct that shocks the conscience, is not one that can be applied by a computer, it at least points the way. Friendly's characteristically trenchant observation is well taken. Neither the shocks the conscience test nor common law review can be applied by a computer, nor should we wish they could be. As I have emphasized throughout my discussion of common law review, common law adjudication requires the infusion of human values into the law through the efforts of judges to reach decisions informed by their own experiences and evaluations, tempered by reason, reflection, and, as stated in the Rochen opinion, the habit of self-discipline and self-criticism, in certitude that one's own views are incontestable and alert tolerance toward views not shared. These are, as Frankfurter stressed in Rochen, precisely the presuppositions of our judicial process. They are precisely the qualities society has a right to expect from those entrusted with judicial power. We want judges, not computers, deciding cases. B. Adjudging a statute void. The form and exercise of common law review. In the previous section, I mentioned that common law review permits judges to void the legal effect of governmental action. This harkens back to an issue raised by Bonham. What does it mean to adjudge a statute void? Adjudging a statute void amounts to a statement of invalidity, the impact of which varies in different legal systems and in different circumstances within the same legal system. Earlier, I identified this as a contingent fact about the form of this judicial power. It seems to me that there are three things we might mean when we say that a court has adjudged a statute void. First, we could mean that the court, in its written opinion, declared the statute inconsistent with its nation's body of law and legal principle, but did not bind the parties in any fashion or otherwise impair the statute's viability. An example of this sort of authority is found in the power of the English judiciary to issue a declaration of incompatibility in accordance with the Human Rights Act of 1998. Second, we could mean that the court refused to apply or enforce the statute against a particular party in a particular case, but did not excise the statute from the nation's body of law, although the court's written opinion will then become a part of that jurisdiction's precedential material. Third, we could mean that the court refused to enforce the law in a given case, with the effect that the law has no further legal existence and is eliminated as a legal source, as though the statute never existed. This is the power and effect of constitutional review in the U.S. legal system. I will refer to these three possible meanings of adjudging a statute void as declaration, repudiation, and elimination, respectively. Common law review, as I conceive it, calls for something more than declaration, because declaration permits judicial enforcement of an unjust statute against the litigants who are before the court. Declaration leaves the obligation to change the law to the legislature, and as I have already explained, this is an unsatisfactory solution to the problems posed by unjust laws. Although elimination is inoffensive to me, and not inconsistent with the overall theory, common law review does not necessitate a judicial power of elimination. So long as the judge is legally empowered to refuse to enforce a law that she determines to be intolerably unjust, there is no necessity that her judgment result in the offending law's complete eradication from the corpus of legal sources. Some might say that even in the absence of an acknowledged power to eliminate offending legislation, a judicial authority to refuse to enforce unjust statutes is itself sufficient to remove the statute from the jurisdiction's body of legal sources. I do not go this far. My goal is only to establish the judicial authority to refuse to enforce unjust laws in particular cases. I am willing to concede that these statutes may retain legal status and force until they are formally repealed or abolished by an authority acknowledged within the given governmental and legal system as possessing that power. The resulting status of these unjust laws following judicial repudiation is not my primary concern, although a judge's explicit refusal to enforce the statute will undoubtedly impair its legal force to some degree. The principal objectives of common law review are to ensure a judge's legal ability and authority to spare parties from the consequences of an unjust law, and to allow the judge to contribute a candid written opinion as a source of precedent that explains the reasons for her refusal, without unduly altering the allocation of powers within the governmental system. Accordingly, repudiation is the form of judicial power common law review requires. C. Applying and developing the law. Common law review, stare decisis, and legislative supremacy. Judges, I have argued, have two fundamental legal obligations: to apply the law and to develop the law. Unjust laws bring these obligations into conflict. When a judge is asked to enforce an unjust law, the obligation to develop the law overrides the obligation to apply the law. I will now explain, with more precision, exactly how these two obligations interact. More specifically, I will explain how common law review, as the legal doctrine embracing the judicial obligation to develop the law, can coexist with stare decisis and legislative supremacy, the legal basis for the judicial obligation to apply the law. In addition, I will continue to examine these fundamental judicial obligations in the context of threats to the judiciary as an institution traditionally charged with ensuring that the government acts in accordance with the rule of law. In other words, I will continue to examine how common law review relates to, reinforces, and reflects common law constitutionalism. A bit later in this chapter, I will discuss a legislative challenge to the judicial obligation to ensure the legality of government action in the form of statutory provisions that attempt to strip the courts of jurisdiction to review acts of the government. In the next section, I consider a perceived threat to the court's institutional integrity stemming from the decision of a state high court. The case example in the next section also happens to involve the reaction of an appellate court judge to a decision of the high court in his jurisdiction. Regardless of what one ultimately concludes about the ability of lower court judges to resist decisions of high courts, this case also raises important questions about the obligation of judges to maintain the character of the judicial institution against challenges to the judiciary's institutional integrity, whether derived from legislation, executive action, or judicial decision. 1. Stare decisis. Stare decisis requires judges to enforce precedent, and legislative supremacy or primacy requires judges to enforce statutes. The epistemic threshold provides an analytic tool with which judges determine when their obligation to enforce precedents or statutes is overridden by their obligation to develop the law. At least where horizontal stare decisis is concerned, there is no reason to think that common law review's relationship with stare decisis presents any unusual difficulties for high courts and appellate courts beyond those encountered by judges whenever they decide to deviate from precedent. These cases always force judges to balance stability against substance. Ordinarily, social and legal interests in certainty, predictability, and the satisfaction of litigants' expectations will tip the balance in favor of stare decisis and the status quo. Occasionally, however, when a particular precedent strikes judges as importantly mistaken, the balance will tip toward the improvement of the law's substantive merit, the departure from precedent, and the establishment of a new rule. To be sure, different judges, lawyers, and theorists will conclude that the balance between stability and substance should be measured in different ways. But as a matter of principle, the attempt to achieve this balance has always been at the heart of the common law judicial process. Stare decisis has never been used as an excuse for judicial inaction that amounts to an abandonment of this court's duty to guide and develop the common law of this state. Our common law, which is of judicial origin, is comprised of broad, flexible principles that find their source in fundamental values of justice, logic, and common sense, and is adapted by the judiciary according to the changing demands of our society. We find no wisdom in abdicating to the legislature our essential function of re-evaluating common law concepts in light of present-day realities. Nor do we find judicial sagacity in continually looking backward and parroting the words and analysis of other courts, so as to embalm for posterity the legal concepts of the past. As these principles demonstrate, the rule of stare decisis is not so static that it deprives the court of all power to develop the law. The maintenance of stability in our legal concepts does not, and should not occupy a preeminent position over the judiciary's obligation to reconsider legal rules that have become inequitable. The common law has always permitted horizontal stare decisis to yield to the judicial obligation to develop the law. The area of vertical stare decisis is where problems arise. Here I embark on the most unorthodox part of my argument. In those extreme circumstances where a judge is firmly convinced that the epistemic threshold has been breached, common law review permits the judge to refuse to enforce precedent of a higher court. Having just written this, I feel the need to take a deep breath. I realize the reactions this claim is likely to elicit. Yet even this claim is not without legal foundation. There are rare cases where trial and appellate court judges, chose not to follow the precedent of the high courts of their jurisdiction. One well-known example is Barnett v. West Virginia Board of Education, where Judge Parker, sitting in a 3-judge panel, declined to follow the Supreme Court's decision in Minersville School District v. Gobides. In Gobides, the Supreme Court had held that the school district of Minersville, Pennsylvania, could legally prohibit Lillian and William Gobides, aged 12 and 10, from attending public school, because Lillian and William refused to salute the American flag, in keeping with their religious belief as Jehovah's Witnesses that the Bible is the supreme authority and that a gesture of deference toward the flag was forbidden by Scripture. Parker refused to follow Gobides, noting that of the 7 sitting members of the Supreme Court who participated in Gobides, 4 had publicly expressed their belief that the decision was incorrect. Parker also cited a later case in which the majority of the court declined to rely on Gobides as authority. Parker's decision was vindicated. The Supreme Court upheld his ruling and overruled Gobides. Helpful as Barnett is to my argument, Parker's reliance on critical public statements by sitting justices limits its relevance somewhat for my purposes. Another case provides an even more compelling example of a judge refusing, for reasons of principle and conscience, to follow precedent of a higher court. This case is Morrow v. Hood Communications, Inc., in which the California Court of Appeal addressed the enforcement of a stipulated reversal of judgment. Unique to California law, stipulated reversals were sanctioned by the California Supreme Court's decision in Neary v. Regents of University of California. As authorized by Neary, in the absence of extraordinary circumstances, a stipulated reversal permits litigants to facilitate the settlement of a lawsuit by filing a joint application to an appellate court seeking the pro forma reversal of a trial court judgment, without any contention that the trial court judgment is legally deficient in any way. As support for the practice of stipulated reversals, the Neary majority relied on the public policy favoring settlement of litigation, the court's power to control judicial proceedings, the appellate court's inherent authority to reverse trial court rulings, and the inability of trial courts to establish binding precedent. In reaching its decision, the Neary majority reversed the decision of the California Court of Appeal and rejected the reasoning of dissenting California Supreme Court Justice Joyce Kennard. Fundamental to the Neary majority's disagreement with the Court of Appeal and Justice Kennard are 2 points. First, Kennard and the Court of Appeal shared concerns about the purpose of the judicial process and the judicial system. Kennard argued, more than just a dispute resolution service, the judiciary is an integral part of our government, working in the context of actual disputes. When a trial court renders judgment in a particular case, it is not just deciding who wins and who loses, who pays and who recovers. Rather, the ultimate purpose of a judgment is to administer the laws of this state, and thereby to do substantial justice. Second, the Court of Appeal noted the value of the trial court's decision as a source of guidance and precedent for judges and lawyers. The Neary majority challenged both of these points. Regarding the purpose of the judicial institution, the Neary majority stated, the primary purpose of the public judiciary is to afford a forum for the settlement of litigable matters between disputing parties. The Court of Appeal's concern for the integrity of trial court judgments is flawed. The notion that such a judgment is a statement of legal truth places too much emphasis on the result of litigation rather than its purpose. Where the precedential value of the trial court's decision is concerned, the Neary majority reasoned that trial court decisions have no such value, since trial courts make no binding precedents. Underlying the Neary court's view on this point are the nested, unstated premises that a court's opinion must be precedent to have value, and that a court's decision must be binding to be precedent. This was not the California Court of Appeal's understanding of precedent, and as I have already explained, it is not mine either. With this discussion of Neary in mind, we can look at Morrow. Morrow involved an application by litigants for a stipulated reversal of a trial court judgment. Morrow came before the Court of Appeal 5 years after Neary was decided. Neary was, under applicable principles of vertical stare decisis, binding precedent for the Court of Appeal. Nevertheless, Anthony Klein, presiding justice of the Court of Appeal, declined to follow Neary. There are rare instances in which a judge of an inferior court can properly refuse to acquiesce in the precedent established by a court of superior jurisdiction. This is, for me, such an instance. I acknowledge that the opinion of the California Supreme Court in Neary v. Regents of University of California requires that the motion before us be granted. I would deny the motion, however, because I cannot as a matter of conscience apply the rule announced in Neary. Based on my deeply felt opinion that the doctrine of stipulated reversal announced in Neary is destructive of judicial institutions. The debate in Neary pertains to the role of the courts. The judicial responsibility is fundamentally public. Judicial officials, like members of the legislative and executive branches, possess a power that has been defined and conferred by public law, not by private agreement. Their job is not to maximize the ends of private parties, nor simply to secure the peace, but to explicate and give force to the values embodied in authoritative texts, such as the Constitution and statutes, to interpret those values and to bring reality into accord with them. The parties in this case waived a jury and submitted their dispute to the Honorable Harlan K. Veal, Judge of the San Mateo Superior Court. After conducting a public trial, Judge Veal made a variety of factual determinations and on that basis rendered judgment for the plaintiff. For reasons not revealed by the record, the defendants induced the plaintiff to agree to the reversal of that judgment as a condition of settlement. This bargain would have been pointless unless defendants believed our order would cast doubt on the validity or force of the judgment of the trial court. The parties have not, however, even claimed, let alone shown, that the judgment rendered by Judge Veal is erroneous in any way, and it remains presumptively correct. The reversal of such a judgment is either a travesty or a charade. In either case, I refuse to participate. My conscientious refusal to acquiesce is not designed to offend our Supreme Court, for which I have the most profound respect. It is constitutionally justified, and I hope constructive. Klein's opinion demonstrates that, while rare, it is not unheard of for lower court judges to refuse to enforce higher court decisions as required by vertical stare decisis. In certain exigent circumstances, judges may follow their convictions rather than precedent. Moreover, these rare circumstances need not undermine the structure or stability of a hierarchical judicial system. Klein went on to observe in Morrow, so long as the lower court may still be reversed by the higher court, there is no interference with either the supremacy of the Supreme Court or with the idea of the rule of law. Indeed, quite to the contrary, such underruling may be an essential part of the process of judicial self-correction. A judge who declines to enforce an unjust precedent in accordance with his deeply felt beliefs and who records the reasons for his refusal in a candid opinion contributes as much as he can within his defined role to the development of the law, even where his opinion is written in dissent, or is certain to be reversed on appeal to a higher court. It is incumbent on the judge in the lower court to enunciate for the law his best reasoned opinion as to why he believes his refusal to enforce an unjust law is legally justified, because society does not have such confidence in the superior wisdom of higher judges that it wants their judicial inferiors to abdicate all independent judgment. What the law ultimately does with the judge's opinion is not up to him. Through his conscientious effort to develop the law, the judge does as much as he can. A doctrine as powerful and important as vertical stare decisis may succumb, in a very narrowly circumscribed set of cases, to the dictates of a judge's conscience and to his countervailing obligation to contribute to the law's development. Moreover, the hierarchical structure of the courts must be considered as a feature of the institutional nature and purpose of the judiciary. In Morrow, Klein concluded that the integrity of the judicial process was his paramount consideration, even when viewed from his place within the judicial hierarchy, because ultimately the hierarchical structure of the courts exists to maintain the integrity of the institution. In the extraordinary circumstances of Morrow, Klein ultimately determined that his obligation to the integrity of his institution outweighed, even his place within the hierarchy of that institution. Even though judges cannot bind courts above them in the hierarchy, this does not mean that the judge's decisions are without worth or influence. Decisions of lower courts may persuade other courts by the force of the supporting rationale. As I argued in the previous chapter, judges at every level of the hierarchy owe to the law and to the public the benefit of their rationale. This is true of trial court judges and judges writing in dissent. This is true even where a judge finds himself alone in his convictions, with an opinion that is likely to be little more than a still small voice in the legal wilderness. In fact, these may be the most important occasions for a judge to record his reasons. He is speaking not to his colleagues, but to his successors. He is speaking to the future. Neither horizontal nor vertical stare decisis can overcome the judge's obligation to develop the law in those rare cases where a judge concludes, after careful reflection, that the law undermines the institutional integrity of the court or is otherwise fundamentally unjust. Once the epistemic threshold has been reached, a decided case is worth, as one opinion puts it, as much as it weighs in reason and righteousness, and no more. Though issued in dissent, Klein's principled refusal to follow Neary met with heated resistance. The California Commission on Judicial Performance filed judicial misconduct charges against him that could have resulted in censure or removal from the bench. But Americans overwhelmingly understood that he should not, as a judge, be subjected to disciplinary action for registering his opinions about the law and his legal responsibilities. In fact, in response to the Commission's action against Klein, the California legislature passed 2 statutes, one of which would prohibit the Commission from disciplining judges for issuing opinions that are legally incorrect or issuing dissents that do not follow the precedent of a higher court. The California legislature was not finished, however. No doubt due in part to Klein's opinion in Morrow, the California legislature significantly limited the practice of stipulated reversal in California courts. The statute that took effect on 1 January 2000 stated, "An appellate court shall not reverse or vacate a duly entered judgment upon an agreement or stipulation of the parties, unless the court finds both of the following. A. There is no reasonable possibility that the interests of non-parties or the public will be adversely affected by the reversal. B. The reasons of the parties for requesting reversal outweigh the erosion of public trust that may result from the nullification of a judgment and the risk that the availability of stipulated reversal will reduce the incentive for pretrial settlement." The influence of Klein's and Kennard's dissents is manifest in this statute. The factors delineated in the statute are evident throughout the opinions of both justices. Klein and Kennard wrote their dissenting opinions in a concerted effort to improve California law. Klein's dissent in Morrow went even further. Out of respect for the judicial institution and the public interest, and despite the strong pull of vertical stare decisis, Klein refused to follow a higher court precedent. Now Klein's opinion is itself a source of guidance and legal reasoning to which other judges can turn in the future, when their consciences call to them to forestall injustice or unfairness, to improve the law. 2. Legislative supremacy. The dialogue between California's courts and its legislature about the efficacy and equity of stipulated reversals, resulting in the legislature's statutory enactment, is a good illustration of courts and legislature working together to ensure the law's overall fairness. The California example is just one instance of cooperation between courts and legislatures in their joint responsibility to ensure that the law is as just and fair as possible. The courts and the legislature operate with the awareness that, ultimately, common law and statute law coalesce in one legal system. Although there are, without question, occasions of friction between governmental branches, the judiciary and the legislature are not engaged in an internecine battle to grab and maintain the lion's share of legal power. Generally speaking, each views and treats the other's legal pronouncements with deference and respect. The reciprocal deference and respect of legislatures and judiciaries in common law jurisdictions helps to illustrate that judicial review, in its constitutional or common law incarnation, need not undermine the legal or political authority of the legislature. When a court refuses to enforce a statute, the legislature will usually accept that the court is acting out of its best judgment about the law and will frequently alter or amend the statute in response to the court's concerns. For their part, courts are circumspect in exercising this power because they recognize that the legislature acts, most of the time, out of its best judgment about the interests of the nation and the majority of its citizens. The relational structure of our governmental institutions imparts the principal lawmaking function to the legislature, in any event. This is what I have called legislative primacy. Moreover, the judiciary's respect for legislative primacy is not inconsistent with a recognized legal power of judicial review. It is as much our inclination, as it is our duty, to receive with all possible respect every act of the legislature, and that we never can find ourselves in a more painful situation than to be obliged to object to the execution of any act. But we are under the indispensable necessity of acting according to the best dictates of our own judgment, after duly weighing every consideration that can occur to us. This balance between legislative primacy and judicial responsibility is aptly expressed in David Deisenhouse's notion of deference as respect. As Deisenhouse describes it, this notion invokes not the idea of deference, in its primary Oxford English Dictionary meaning of submission to the commands of an authority, but rather, deference according to the secondary meaning, deference as respect a judicial attitude of respectful attention to the reasons which are or could be offered in support of a legal authority's decision. The notion of deference as respect requires judges not to countermand legislation unless 1. There is no formulation or interpretation of the statute that can save it from its defects, and 2. There is no other basis on which the case could be decided. When legislation cannot be saved, however, it falls to the courts to renounce it, and deference must yield to duty. As Chief Justice Marshall noted in Fletcher, judges must be reluctant to exercise their authority to interfere with legislative pronouncements, yet unafraid to meet their duty when absolutely necessary. The question, whether a law be void for its repugnancy to the Constitution, is at all times a question of much delicacy, which ought seldom, if ever, to be decided in the affirmative in a doubtful case. The court, when impelled by duty to render such a judgment, would be unworthy of its station, could it be unmindful of the solemn obligations which that station imposes. But it is not on slight implication and vague conjecture that the legislature is to be pronounced to have transcended its powers, and its acts to be considered as void. The opposition between the Constitution and the law should be such that the judge feels a clear and strong conviction of their incompatibility with each other. With its references to the judge's necessarily clear and strong conviction that cannot be satisfied by slight implication and vague conjecture, and to the solemn obligations that the judge's station imposes, the preceding passage appropriately characterizes the judicial attitude that underpins common law review's epistemic threshold. Common law review permits a judge to refuse to apply a statute only when no other avenue apart from enforcement, resignation, or prevarication is left open to him. In its application to common law review, the notion of deference as respect does not threaten the authority of the legislature. In all but the most extraordinary cases, judges will enforce the law as the legislature has enacted it. Judges must, except when exercising the power of judicial review, defer to the decisions of legislatures. But deference as respect and common law review indicate that deference does not demand undeviating subservience. Just as deference and judicial independence are not mutually exclusive, neither are deference and legislative primacy. The need to balance stability and substance in the legal system requires courts and legislatures to respect each other's decisions, even though they will sometimes disagree. The need to balance stability and substance in the law requires judges to offset their respectful deference toward the decisions of the legislature or another court against their independent assessment of the law's fairness and ongoing development. In the end, balancing stability and substance demands that judges must weigh their obligations to apply the law and to develop the law. In most cases, the doctrines that contribute to the law's stability, stare decisis, and legislative supremacy will carry the day. In some cases, however, a judge will conclude that something weightier sits on the other side of the scales. In these cases, the judge's obligation is to contribute what he can to the law's development, to work the law pure. When balancing the obligation to apply the law against the obligation to develop the law, common law review attempts to free judges from an excessively formalistic perception of legal doctrines, such as legislative supremacy and stare decisis. According to common law review, judges would frankly recognize both that legislative supremacy does not entail that courts always follow legislative rules, and that faithfulness to higher courts does not entail that lower courts always follow their rules. D. Common law principles and rule of law values. The example of ouster clauses. In thinking about how common law review would operate in practice, it might be helpful to explore in more detail some concrete contemporary situations in which common law review is appropriate. In the next chapter, I will examine a specific example of a common law principle of constitutional dimension that operates to maintain constitutional limitations on government action. In this chapter, I will consider an example of judges maintaining the constitutional relationship of government organs in response to legislative attempts to alter that relationship. Judges in England and the United States frequently refuse to enforce statutory provisions that purport to divest the courts of jurisdiction to review certain administrative determinations and other uses of public power. These statutory provisions that attempt to exclude certain government actions from judicial evaluation are referred to as ouster clauses, privative clauses, or jurisdiction strip-ping clauses. As with Justice Klein and Morrow, these cases involve judges reacting to what they perceive to be a fundamental threat to the integrity of the judiciary as an institution, to their obligations as judges, and to the constitutional commitments of their government. The most famous English case involving an ouster clause is Annis Minnick. In Annis Minnick, the House of Lords addressed the Foreign Compensation Act of 1950. The act contained an explicit ouster clause in Section 44. The determination by the Foreign Compensation Commission of any application made to them under this act shall not be called in question in any court of law. The Foreign Compensation Commission argued that the language of the statute was transparent and not open to interpretation. The appellants argued that the word determination in Section 44 could refer only to a substantively valid determination rather than to a compromised determination that lacked any legal weight or import. They claimed, if you seek to show that a determination is a nullity, you are not questioning the purported determination, you are maintaining that it does not exist as a determination. The House ruled in the appellant's favor. According to Lord Wilberforce, the Commission misapplied the requirements of the 1950 Act. Article 4 should be read as if it imposed 3 conditions only on satisfaction of which the applicant was entitled, under statutory direction, to have his claim admitted, namely a. that his application related to property in Egypt referred to in Annex E-B, that he was the person referred to in Annex E paragraph 1A as the owner of the property, c. that he was a British national at the specified dates. As ex concessus, all these conditions were fulfilled to the satisfaction of the Commission. The appellant's claim was in law established. The Commission, by seeking to impose another condition, not warranted by the order, was acting outside its remitted powers and made no determination of that which alone it could determine. The Commission incorrectly imposed a condition on the appellants that was not statutorily required, namely, that their successor in title must be a British national. Although Annis Minnick could not satisfy this condition, Wilberforce noted that the 1950 Act did not require Annis Minnick to do so. In other words, the Commission applied a legal test to Annis Minnick that the Commission was not empowered to apply. The Commission could not, Wilberforce concluded, avoid judicial review of its decision under the 1950 Act simply by calling its decision a determination. The respondent's argument that the Commission has only to make a self-styled determination in order to enjoy automatic protection is thus at once seen to be unsustainable. Wilberforce accepted the appellant's argument that some determinations of the Commission were legal nonentities. They were nullities with no legal merit or meaning, and the ouster clause did not prevent the courts from reviewing these administrative decisions to ensure that they complied with the law. Despite the apparent clarity of Section 44, the House refused to permit Parliament to oust its jurisdiction over an otherwise justiciable matter. Anisminic is substantial evidence for the claim that English courts will, when pressed sufficiently, refuse to enforce parliamentary legislation that is deemed to undermine the very foundation of the English judiciary's institutional competence and constitutional obligations. In its support for the proposition that English courts will sometimes refuse to enforce parliamentary legislation for reasons of principle and to maintain the rule of law, Anisminic also supports the principle of common law review. Similarly, U.S. courts resist perceived legislative incursions into their jurisdiction. In general, federal courts differentiate between legislative preclusion of statutory claims and legislative preclusion of constitutional claims. And while federal courts will usually accede to legislative preclusion of review of statutory claims, they are much more resistant to statutory attempts to preclude judicial review of substantial constitutional claims. Webster v. Doe is a characteristic example in this regard. Webster involved an employee of the Central Intelligence Agency who was dismissed due to his sexual orientation. Doe sued the agency, in the person of the director, for statutory and constitutional violations. The agency responded that Section C of the National Security Act precluded judicial review of the director's termination decision under the Administrative Procedure Act. Specifically, Section 701A of the APA stated, "This chapter applies according to the provisions thereof, except to the extent that 1. Statutes preclude judicial review, or 2. Agency action is committed to agency discretion by law." The agency argued that the National Security Act, read in conjunction with Section 701A of the APA, precluded any court from reviewing Doe's statutory and constitutional claims. The Supreme Court accepted the agency's argument that Doe's statutory claims were precluded from review. But the court rejected the agency's claim that, no matter what the nature of respondents' constitutional claims, judicial review is precluded by the language and intent of 102C. Because all agency employment termination decisions, even those based on policies normally repugnant to the Constitution, are given over to the absolute discretion of the director, and are hence unreviewable under the APA. Writing for the court, Chief Justice Rehnquist refused to view Section 102C as ousting its jurisdiction over Doe's claims of constitutional violation. We do not think 102C may be read to exclude review of constitutional claims. We emphasized in several cases that where Congress intends to preclude judicial review of constitutional claims, its intent to do so must be clear. We require this heightened showing in part to avoid the serious constitutional question that would arise if a federal statute were construed to deny any judicial forum for a colorable constitutional claim. Rehnquist's opinion in Webster bears, in many respects, a strong family resemblance to such English decisions as Anisminic. In these cases, the Supreme Court and the House of Lords seem to be saying that Congress and Parliament might assert the theoretical authority to extinguish any judicial review of the legality of certain administrative actions. However, these cases also indicate that Congress and Parliament cannot entirely strip the judiciary of its constitutional role and institutional authority to ensure that the government acts in accordance with the law. Despite the presence of legislative supremacy, and the absence of a written constitution in England, and the absence of legislative supremacy, and the presence of a written constitution in the United States, English and American courts respond to statutory ouster clauses in strikingly similar ways. These judicial responses to legislative attempts to circumvent or eliminate the court's traditional constitutional role demonstrate the commitments of the Anglo-American legal tradition to the rule of law and to an independent judiciary that maintains legal limitations on government through the recognition and enforcement of fundamental rights and principles. These commitments are actually more meaningful indicators of the nature of the Anglo-American legal and political structure than either the existence of a written constitution or references to parliamentary sovereignty. I explore the relationship between common law, constitutionalism, and legislative power, and the ultra vires doctrine in more detail in the next chapter. For now, my point is that the decisions of courts in England and the United States demonstrate that judges will not lightly permit their jurisdiction to be ousted and their constitutional obligations to be extinguished by legislative provisions. To maintain constitutional commitments to rule of law values, the courts of the United States and of the United Kingdom recognize fundamental principles through which those commitments are enforced in court. A useful example, taken from English law, of a specific fundamental common law principle that functions at a constitutional level to ensure the maintenance of rule of law values is the right of access to the courts. I discuss another of these principles in Chapter 9. In Chapter 5, I considered the connection between the correct reading of Bonham and the co-equal position of the organs of government in common law systems. The refusal of English and American judges to permit ouster clauses to undermine their institutional authority to ensure that public power is exercised only within legal constraints is another reflection of this constitutional balance and relationship of powers. English and American cases establish that in the view of judges, their power to review the constitutionality of government action is intrinsic to the Anglo-American commitment to the rule of law. English judges and American judges use different terms to describe the fundamental rights and principles involved when individuals raise constitutional challenges to the actions of government. However the principles are described, though, the consistency of the court's reactions and the shared refusal of English and American judges to accept legislative preclusion of their jurisdiction is a noteworthy demonstration of the realization of common law constitutionalism in the preservation of jurisdiction to review the legal legitimacy of government action. Responding to Radbruch. Before concluding my discussion of the analytic features and practical applications of common law review, I should try to preempt a possible misunderstanding. In previous chapters, I described some distinctions between common law and natural law in the analysis of English and U.S. case law. I should also explain an important and related distinction at a more theoretical level. In the wake of World War II and the fall of the National Socialist government in Germany, Gustav Radbruch renounced legal positivism as partially to blame for the acquiescence of so many German lawyers and officials in the atrocities committed by the Nazis in the name of law. In their famous exchange in the Harvard Law Review, H.L.A. Hart and Lon Fuller debated the accuracy of Radbruch's conclusion that positivism was partly responsible for the legal injustices of the Third Reich. Rather than enter into the debate over Radbruch's claim that positivism engendered submission to the Nazi subversion of German law, which is not my concern here, I want to address a possible response to my argument that relates to the discussion of Radbruch by Hart and Fuller. Radbruch was a German legal theorist writing about a period in German legal history. Despite this distance from the common law tradition, considerations of Nazi law unavoidably influence almost any contemporary analysis of unjust laws. Moreover, and more to the point, some might think that my argument about judicial resistance to injustice in the common law tradition draws on or substantially reproduces claims made by Radbruch. This is the possible misapprehension that I want to prevent. In his renunciation of positivism, Radbruch developed an orientation toward unjust laws that is now referred to as the Radbruch formula. Robert Alexie explains that this formula has two parts. The first part is the claim that positive law loses its legal validity when its contradiction with justice reaches an intolerable level. The second part of the formula states that positive law is denied legal status when equality is deliberately disavowed in its enactment, or in other words, when justice is not even aimed at. Alexie restates the formula more straightforwardly. Appropriately enacted and socially effective norms lose their legal character or their legal validity when they are extremely unjust, or extreme injustice is no law. Julian Rivers notes that by denying the legal validity or character of powerfully unjust laws, Radbruch's formula is none other than a modern-day version of Augustine's lex injusta non est lex, with the gloss that the injusta must be extreme. Given the emphasis earlier in this chapter on the severity of the injustice involved as a dispositive criterion for the exercise of common law review through the epistemic threshold, and on the obligation of common law judges to refuse enforcement of egregiously unjust laws via what I have called repudiation, it might seem that my argument tracks Radbruch's formula. This is not the case, however, for two reasons. First, I do not argue that law loses its legal validity when it reaches an intolerable level of injustice. On my account, unjust laws are still laws. In fact, my argument about judicial function and obligation within the common law tradition requires that unjust laws retain their character as laws no matter how unjust they might be. To take a famous example, if Parliament enacted a statute requiring the execution of all blue-eyed babies, simply denying that the law possessed any validity ab initio, as law would misrepresent and oversimplify the problems created by that law. The purpose of my argument is to acknowledge that such an intolerably unjust law possesses legal validity, and then to consider whether any systemic response to such a law is available within the common law tradition, rather than attempt to convert common law tradition into natural law theory. I attempt to offer an argument grounded in the doctrine and nature of the common law itself. Second, I do not claim that enacted law loses its legal status whenever a deliberate disavowal of equality or failure to aim at justice occurs during the legislative process. Again, I assume the opposite. I assume that the proposed law against blue-eyed babies would retain its status as law, even if Parliament deliberately disavowed equality and did not attempt to aim at justice during its enactment. Radbruch's formula is an attempt to avoid the problems posed by unjust laws by denying that they are laws. My argument is an attempt to address the problems posed by unjust laws by exploring these problems within the legal sources and concepts of the common law tradition. My argument is not a general argument about the nature of law. It is a contextual argument about the doctrines and concepts of the common law. Of course, very few natural lawyers have ever accepted the lex injusta formula endorsed by Radbruch. Part of the reason for this is that saying unjust laws are not laws will not make them go away. An attempt to address the difficulties raised by unjust laws must begin with the recognition that they are laws. The neutralization of unjust laws requires that an institution within a legal tradition respond based on legal arguments from within that tradition's sources, concepts, and history. Rivers attempts to integrate Radbruch's formula into a common law framework by relying on theories of interpretation. According to Rivers, such integration would mean that we do not have to deny entirely the legal validity of unjust laws. Instead, he argues, we could place the possible interpretations of an unjust law on the scale of political morality and conclude that the adoption of an interpretation that deviates grossly from that indicated by conventional canons of interpretation requires a very strong appeal to abstract justice if it is to be legitimate. For the reasons I explained in Chapter 3, I do not believe that theories of interpretation can extricate us from the quandaries created by unjust laws. For similar reasons, Rivers's effort to resuscitate Radbruch's formula by turning to interpretation is unpersuasive. In the end, no appeal to abstract justice, however compelling, can legitimate a desired result that is fundamentally groundless in a given legal system. Natural lawyers can be common lawyers. John Finney's is one, but Radbruch's lex injusta formula cannot be harmonized with the common law's sources, method, and history. Rivers seems to concede this point to some extent. In the following passage, he contrasts the challenges unjust laws pose for judges during and after the existence of an evil regime. In one sense, adjudication becomes easier under an evil regime. The requirements of fairness are weakened in the case of laws passed by undemocratic tyrannies, so the radical reinterpretation of such laws in accordance with standards of abstract justice is proportionately more legitimate. But the practical stakes for the conscientious judge, whose conception of justice puts him at odds with the government, are much higher. Certainly, he does not have to resign in advance, but he is more likely to be dismissed or worse. Adjudication in the aftermath of an evil regime reverses the difficulties. It is politically easier, but intellectually more complex. Courts adjudicating in the aftermath of an evil regime are only observers of an historically completed process. They cannot legitimize unfair readings of statutes in the name of integrity by appealing to the consequent reconciliation of justice and fairness within the law that their interpretation achieves. Rivers argues that it is legitimate for conscientious judges under an evil regime to reinterpret unjust laws radically in the pursuit of abstract justice. Rivers's way of expressing this form of radical reinterpretation seems dangerously close to what Dworkin identified as a judge lying about what the law is and saying that the legal rights are different from what he believes they are. Even if we assume that this is not what Rivers means here, I want to consider the cases where radical reinterpretation of this sort is unavailable. As I indicated in Chapter 1, I do not believe that an appeal to abstract justice, no matter how well-intentioned or morally desirable, is adequate to justify a reinterpretation of the law that lacks any foundation in common law sources. On this point, Rivers's reference to the circumstances of adjudication in the aftermath of an evil regime recalls the case of Oppenheimer v. Cattermole. In Oppenheimer, the House of Lords was forced to confront a 1941 Nazi law that deprived German Jews of their citizenship and facilitated the confiscation of their property. The House was, of course, deciding a case in the aftermath of an evil regime of a foreign nation. Nevertheless, choice of law doctrine required the House to consider the applicability of this Nazi law in England. The House declined to enforce the Nazi statute, concluding that it conflicted with other sources of law binding in England. More specifically, there is a principle in English common law that creates an exception to the general enforcement of foreign law when the enforcement of foreign law would violate basic principles of justice and fairness, which the courts seek to apply in the administration of justice in this country. Oppenheimer reinforces my claim that principles of justice can be invoked by judges to preclude the enforcement of unjust laws. But unlike Rivers, I argue that these principles of justice are only those articulated in common law sources, not principles of abstract justice. Summing up, I have identified 8 features of common law review as it might operate in practice within an existing common law legal system. First, the epistemic threshold applicable to common law review sets exacting standards of certainty and gravity, which ensure that no judge can properly invoke common law review unless she is as certain as she can be that a mistake was made by a prior court or a legislature, and that this mistake concerns a matter of grave social importance that violates the judge's deepest convictions. Second, the convictions with which common law review is concerned are the judge's own, not the judge's assessment of society's prevailing beliefs. Third, the judge alone must determine, with reference to her personal beliefs and ideals, when the epistemic threshold has been crossed. Fourth, the judge must undertake careful and comprehensive reflection and analysis before concluding that a particular law meets the epistemic threshold and triggers common law review. Fifth, if the judge finally concludes that the exercise of common law review is warranted, this authority overrides any conflicting legal principle, including stare decisis and legislative supremacy, and requires the judge to develop the law by refusing to enforce the law deemed to be unjust. Sixth, common law review empowers judges to refuse to enforce an unjust law only in particular cases. Common law review does not demand that this refusal have the legal effect of striking a precedent or statute out of the body of existing law in a jurisdiction, unless the court in question is the high court of a jurisdiction whose rulings are understood to have that effect. Seventh, common law review is consistent with judicial respect for doctrines of legal stability, such as stare decisis and legislative supremacy, which are overridden only in the most drastic circumstances. Finally, common law review allows the courts to resist threats to its institutional integrity and reinforces the judiciary's institutional obligation to maintain constitutional restrictions on the government and to ensure the legality of all government action. Given all of the restrictions this conception places on the practice of common law review, and given all of the other institutional constraints inherent in the judicial process, there is little worry notwithstanding the complaints of certain likely critics that common law review would leave us adrift and listing on a sea of judicial whim and doctrinal instability. On the contrary, the principle I have defended is narrowly confined by the epistemic threshold and the case-specific form of the common law review power. There is no reason to suppose that judges would treat this authority with any less care than they do their other responsibilities. Indeed, there is every reason to believe that judges would view this as their most solemn duty, to be exercised only with the utmost consideration and restraint and only in the rarest of cases. Rather than viewing legal authority as a scarce resource for which the legislature and the judiciary compete, common law review fits within a picture of legal authority that is shared by coordinate and cooperative governmental entities seeking to secure, through their own institutional capacities, a body of law and a legal system that are as fair as possible to those governed by them. According to this picture, the law is limitless in its potential to achieve justice. In its realization of that potential, the law is limited only by the reason, vision, compassion, and imagination of those to whom its expression is entrusted.